Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors Legal Hotline Lawyer, and today we are once again reaching into the Washington Realtors Legal Hotline Mailbag to answer your questions. Today's mailbag question asks, does a suicide, and I often have the same question about any death or often a violent death, murder, does a suicide or murder or even any other death in a property require disclosure for future tenants or buyers? And typically when I receive this question, the question asker wants to know both from the broker's perspective and from the client, the seller's or the landlord's perspective. So those are the two questions that we're going to answer today. Go ahead and pause and think about the answer. The agency law makes it very clear that the broker, whether the broker is involved in the sale of the property or the leasing of the property, broker has no duty to disclose any death that might have occurred in the property previously. We look to the agency law for this very clear direction. The agency law defines material fact and says that all brokers are required to disclose material facts. But part of the definition of material facts carves out certain issues that by definition are not material facts. That part of the definition of material facts says the following: the fact or suspicion that the property or any neighboring property is or was the site of a murder, suicide or other death, rape or other sex crime, assault or other violent crime, robbery or burglary, illegal drug activity, gang-related activity, political or religious activity, or other act, occurrence, or use not adversely affecting the physical condition of or title to the property is not a material fact that a licensee must disclose. I'm going to pause for a second. Great. Brokers don't have to disclose a death in the property. That doesn't answer the question for sellers. And in fact, Washington law does not provide a clear answer for sellers with respect to this question. This question is just like every other question that a seller has to confront in determining whether or not a seller has to make disclosure. Think of any property condition and consider that condition in light of seller's disclosure obligation. Does seller have to disclose any condition that you might be thinking of? The answer to that question has to be determined by seller, and if seller needs assistance, seller's legal counsel. As brokers, you are not licensed to advise sellers as to what they do or do not need to disclose. It's unequivocally the practice of law to determine what constitutes a disclosable or a condition requiring disclosure. When you take the condition that's under consideration and apply it to Washington's law of disclosure and reach your conclusion, applying facts to the law to reach a conclusion is necessarily the practice of law. You cannot advise sellers as to what constitutes an issue that they must disclose. Moreover, it's a high-stakes issue in some respects because if you get it wrong, and who knows whether you get it wrong, I'll tell you who knows, the judge or the jury hearing the question way after the fact when you're the defendant in the courtroom, that's who determines whether you're right or wrong. If you get it wrong and you require the seller to disclose information that the seller wasn't obligated to disclose, and as a result the seller slanders title to their own property, you may have a damages claim to the seller. If you tell the seller they don't need to disclose something, and they did, and the claim comes from buyer, then you may owe a damages claim to the buyer or to the seller actually is who your claim would probably be, because the seller would owe damages to the buyer for having failed to disclose something that the seller was required to disclose. So it can be a high stakes issue. You need to make it a routine practice in your own a provision of real estate brokerage services that when a seller asks you, do I need to disclose the following? Your response is, I'm sorry, I cannot advise you as to what you do or don't need to disclose. You need to talk to your lawyer about that question. Most sellers aren't going to talk to their lawyer. I don't care if the seller doesn't talk to their lawyer. What I do care about is that members of the Washington Realtors aren't out practicing law in this respect, because if you do so, you're doing it not only without a license, but without insurance. Don't give sellers legal counsel about what they should or should not disclose. Back to the question at hand, must sellers disclose a death on the property? I don't know. Washington law has not given us a clear answer on whether sellers must disclose this particular issue. Here's what I do know. Buyer brokers, if your buyer wants to know this information, ask the question directly. Listing brokers are required to exercise reasonable skill and care and to administer the real estate brokerage services in honesty and with good faith. If a listing broker is asked the question directly, has there been a death in this house? Listing broker needs to answer the question honestly. If seller instructs listing broker to not answer that question, then listing broker, you need to have a candid discussion with your seller about how listing broker is supposed to respond to that question in the face of a direct question. Buyers can also ask that question directly of seller to the extent buyer and seller have any interaction, and they may not, with one another. If you have questions on this topic or any other, please send an email to me, legalhotline@warealtor.org. I look forward to hearing from you. I thank you for being a member of the Washington Realtors.